Thanks. Hi, everybody. How's everybody doing today? I hope well. I assume that many of you are attending today because you have some questions in mind, such as whether it makes sense to pursue cases at the federal level in appeals counsel, what are the benefits of doing so, and what you should look for in when choosing what cases you're going to send out for review. And of course, I'm going to assume that a lot of this stems from one main issue that all of us are dealing with currently as practitioners in this field, which is that ALJs at the hearing level are just denying an exorbitant amount of cases on a regular basis. They're denying good cases, cases that should normally be won, and it's very frustrating for your claimants and for the practitioners involved. It's frustrating for the claimants who are losing their benefits that they need desperately in order to make ends meet. It's frustrating for practitioners such as yourselves who handle cases at the administrative level because, quite frankly, you're losing substantial revenue by these unjustified denials. And everybody here, I presume, is frustrated by this. It's a common thing. It's common. I hear from everybody all the time. And people are trying to wonder, how do we deal with this issue? And so they come to the federal level wondering if that's going to help any, and it will. Nowadays, I have to say, and I tell this to everybody, having cases reviewed for federal court appeal nowadays is absolutely mandatory. It's not a maybe, it's not, hey, should I do this? It's not, I'll wait till next time. It is mandatory, and it is mandatory now. It's no longer a choice. This is a necessity for your clients and for the health of your practice, period, end of story. So I guess the one question that a lot of people have is, what should I look for in a case to refer out? Like, what am I looking for when I have a denial and it's sitting in front of me? What do I look for in that denial in order to decide whether I'm going to send it out for federal review? Well, so first and foremost, every case that you receive a denial on should be appealed to appeals counsel. Whether you're briefing that appeals counsel denial or not, whether it's a blank appeal where you just put in something boilerplate or not, it has to go to appeals counsel. You must. It's mandatory at this point. So then the question is, once those appeals counsel denials come back, what should you be sending out for review? And there's a very simple answer to that question. It's simple. It's everything. Absolutely every last denial that you receive should be going to a firm for review for possible federal appeal. It's a necessity for all of your clients who have been unjustifiably denied, and it's a necessity for your practice. You should have as many possible remands as you can in order to give yourself as many chances and bites at the apple to win as many cases as you can in order to maximize your revenue at the administrative level. Every case that you're not appealing to the federal court level is potentially money that you're leaving on the table. If I gave you $10,000 in cash right now and you were holding it in your hand, I don't care how large of a practice you have, anybody, whether you have a small practice or a huge practice, if you're holding on to $10,000 and I said, here's $10,000 and I'll go throw it in the shredder, would you do it? Of course not. But every time that you get a case that is denied, it should be sent for federal review, because if you're not, it's the same thing as taking that money, $7,200 fee or more if it's a fee petition, and throwing it in the shredder. There is no way to view it any other way. And we have 4 firms here today that are available to review these cases, all fantastic attorneys. There's plenty of attorneys here who want to take a look at these cases. You should not be holding on to them. And I'm going to take you step by step now through my calculations to show you what you're leaving on the table. And I'm going to share the screen and I'm going to take you step by step through it. Again, what I'm presenting here today are my estimates. They're just estimates, but I think they're a good snapshot of what you could expect if you pursue every denial to appeals counsel and then pursue every case for merit review at the federal level. It may not be perfect, but it's enough to show you what you're leaving on the table and why you should be sending these cases out for review. So the financial benefits of referring your cases for federal review, it's a handout. I believe Deb will send it through NADR to everybody. But if you want to take a look at it, I have it uploaded to the samples link on my website at thefederalappealsfirm.com. You can just go to the website. It's the first thing under samples, and you can download it there. I'm going to skip over some things and get to the nitty gritty of this. So we've got, a bio of myself and my partner. I'm not going through that right now. It explains what we do, how to increase your revenue, which is exactly what I just said. Refer all your cases out. It explains what we look for in terms of documents we want to take a look at to review. There's a section here on debunked. So these are concerns, like things that have been raised to us before. It's faster to simply start a new claim. Well, you're also dealing with res judicata if you're not going to federal level and just immediately ignoring appeals counsel on federal level and starting a new claim. It's not a good practice, but you can read about that here. You can actually pursue federal level and a new claim at the same time. A lot of practitioners think that if they proceed to the federal level, they have to wait until that's over. It's not true. And so a lot of people think cases appeal federal court are simply bad cases. They cannot be won. They lost it anyway. Again, not true. It's so not true that this is all I do is federal work. I don't do administrative claims. I wouldn't be doing this if I couldn't turn these cases into good cases. And again, you're leaving money on the table. So the question is, how much money are you really losing by not sending your cases out for federal review? And my estimates are that for every 25 ALJ denials that you receive, there's as much as roughly $14,500 to $45,000 in fees that you're leaving on the table by my estimates. And I can take you through this quickly so you can see this, but you're leaving, even a small practice is leaving tens of thousands of dollars on the table by not sending all of their cases out for review, period, end of story. Now, as a lawyer, I can't guarantee a particular outcome in an individual client's case, but based on experience, when you take a cluster of cases, I'm fairly certain that there's going to be cases in there that could be remanded from federal court and turned into money for the individual practitioner at the administrative level. And I have a number of assumptions here. So at our practice, we seem to accept 25 to 40% of all cases that are referred to us, which might be high compared to some other practices, but for conservative purposes, I'm assuming roughly 1 in 4, to 30% of cases that are sent our way, we're accepting. I'm assuming a federal appeal win rate varying because statistics tend to vary. The national average seems to be about 60%. We've had win rates up as much as 75%. It depends on the jurisdiction, a number of factors. So I'm assuming somewhere in the 50 to 75% range to give it an overall possibilities to show you that even at the 50% remand rate, you're leaving tens of thousands of dollars on the table. And then at the administrative level, once you get a remand from the federal court level, I have the statistics based on whether you win half of those cases or upwards of 75% of cases. But a lot of practitioners report that their winning percentage goes up upon remand. So we're going to break this down, and we're going to assume that there's 5 to 10% of appeals counsel cases are just remanded and go back for a hearing to begin with. So if there's 25 cases, let's say there's 23 remaining to go out for federal review. Started with 25, 2 maybe roughly are remands to begin with, just because you filed them. We accept out of that 6 to 8 based on our averages. And we're going to say that on the estimated remand rates from federal court, depending on what percentage gets remanded, anywhere from 3 to 6 of those cases that are appealed will wind up remanded, somewhere in that ballpark range. Again, these are very brushstroke numbers, and statistics tend to change for a variety of reasons, but just to give you an estimate of what you're leaving on the table. So if we're looking at the percentages from these brackets, 3 to 6 cases are remanded, and those go back for administrative hearings, and we're going to say there's a win rate of 50, 60, or 75% for estimates. This area here, I think, is the sweet spot. This is kind of probably what you can estimate easily. Some attorneys and reps report winning 75% or more, some 50%, but ballpark estimate, let's say it's in the 60% range. Out of the remanded cases, then you can expect that you're probably going to win on remand as many as 2 to 4 of those cases out of every 25 that you send out for federal review, which results on a single tier fee agreement of $7,200, because you're probably going to max out the single tier fee agreement by the time it gets back from federal court. Or I've estimated the higher amounts based on fee petitions, possibly $9,000 or $12,000, to give you ballpark estimates depending on maybe you get enhanced fees or not. But even at a $7,200 single tier fee agreement, every 25 cases that are denied that you're not sending out to federal court for review is potentially resulting in anywhere from $14,500 to $28,000 in money that you're leaving on the table, plus the potential that you're leaving money on the table for that appeals counsel case that you might have gotten remanded as well. So this down here represents the potential for adding on top of that 1 or 2 appeals counsel cases that you wound up with a remand out of that cluster of cases as well. So, 14 plus 7, you're in the $22,000 to $35,000 range right off the bat for every cluster of 25 cases. Again, ballpark figures, I can't guarantee specifics, but based on experience, this is my opinion on ballpark where you could wind up. So on a single tier fee agreement, for every 25 cases you're denied, you're leaving on the table by not sending them out and appealing to appeals counsel anywhere from $14,500 to $29,000 plus whatever from appeals counsel. And on a 2-tier fee petition, of course, it could be more, but of course you got to wait for that, right? You have to fee petition, so you're going to wait indefinitely. So it depends on your practice decisions on whether you're going single tier or 2-tier. And when you extrapolate that out, as your practice grows, or depending on the number of appeals counsel denials you actually have, when you increase the number of appeals counsel denials that you have, and then you start sending them all out, you'll see that you can be leaving tens of thousands of dollars. And depending on the size of your practice, hundreds of thousands of dollars. And the most sizable of practices could be even leaving millions of dollars on the table. Again, for your client's benefits, you should be sending all these cases out. For the benefit and health of your practice, you should be sending all of these cases out for review. So when the question is, what should I be sending out? What should I be looking for? You shouldn't have to look for anything. You should just send them out to people that handle the federal work and let us all take a look at it, because you're getting a fresh set of eyes on it, and we may be looking at it differently. You're in the trenches trying to win these cases. You're looking at it from a fact-based perspective all the time. Can you prove that the client's disabled? From my perspective, I'm not always looking at it quite like that. I'm looking for legal error. Did they follow the rules? Did they follow the case law? Did they follow the regulations? And I'm looking for ways to get that case from federal court back in your hands so that you have a second chance to win, so that you can improve the revenue of your practice. That's what this is about at this point. It benefits the clients. The clients are losing thousands of dollars in back benefits. They're losing their monthly ongoing benefits wrongfully. And essentially, they're being robbed of that, but so are you. Because you're having cases denied that should have never been denied, and it's taking money away from your clients, and it's taking money away from you, and it's time to take a stand. And you have 4 firms here today, all of which who are ready and willing to help. It's time to start sending your cases out for review, all of them. Don't pick and choose. Don't think about it. Don't say, should I send it out? Is it a good idea? Do I have to look for something specific? No, send them. I urge you to send them. And if anybody has any questions at the end of this presentation, we have other people here to speak. By all means, you can ask me questions at that point. And I thank you all very much for the time and opportunity I had to speak to you.
Thank you, Brian.
Thank you.